Good morning, doctor. My name is Ivy Kong Kyu In. In this video, I'm going to discuss the significance of non-traditional trademarks. I would like to begin by giving an introduction to the governing laws of trademarks in Malaysia. The Trademarks Act 1976, TMA 1976, was repealed. The latest governing laws for intellectual property in Malaysia are the Trademarks Act 2019, which will also be referred to as TMA 2019 later in this video, and the Trademarks Regulation Act 2019. As per Section 3, Subsection 1 of the TMA 2019, any signs that can be of graphical representation to differentiate the goods or services from one to another is a trademark. With the new Act, Section 2 of the TMA 2019 has covered an extensive area under the term sign as compared to mark in the repealed TMA 1976. With the inclusion of non-traditional trademarks, are registrable trademarks which includes the shape of goods or their packaging, color, scent, hologram, the positioning, and the sequence of the motion. Non-traditional trademarks are different from the traditional trademarks in the sense that they seek the nature, scope, and economic potential of the traditional trademarks. Non-traditional trademarks are the features that the traders will choose to use repeatedly to attract consumers by expanding the recognition of their goods and services. Besides, the trade-related intellectual property rights, which is known as TRIPS agreement, has provided that non-traditional marks are also included in all kinds of trademarks. The non-traditional trademarks are available for protection, provided that these signs can be used to enable the consumers to identify the sources of the products and services. It is significant for non-traditional trademarks to be recognized because the potential that the consumers are being misled will be reduced. It is because the consumers are able to distinguish the particular goods or services from the market that is overwhelmed with innumerable products and services provided by certain manufacturers and suppliers by identifying non-traditional trademarks of the products, such as scents, words, colors, shapes, or packaging and other features of the goods. Besides, illiterate people can identify the particular products they seek through these olfactory functions, such as smell, or by identifying the shapes or the colors of the products to determine their sources. There are many instances in which scent is successfully registered as a non-traditional trademark. A case in point is the application of floral perfume in tires by a United Kingdom company. Another example is the registration of the bitter smell in the dark flags by a London company. With the melody in Nokia and the Tarzan Yell being registered successfully as sound trademarks, it may be seen that the sound signs can satisfy the requirement of being graphically represented easier as compared to the other non-traditional trademarks by the expression of a series of musical notes, regardless of whether the words are used. To further illustrate, in Eastman Photographic Materials Company Limited and John Griffith Cycle Corporation Limited and Kodak Cycle Company Limited, an injunction was granted by the English court to prevent the defendant from using the plaintiff's word Kodak as a component of his company name. Since Kodak is an inventive word that cannot be found in a dictionary, it can be relied on by the customers to identify the sources of the products and services of the company. Another example is seen in the case of Fumakila Limited and the Registrar of Trademarks. It can be seen that despite being a foreign language Japanese, kaori can still be considered as an inventive word, as the word inventor is distinct. It is because Malaysians generally do not understand the meaning of the word kaori, as it combines both Japanese and foreign language. In regards to the color trademarks, there are also some successful registrations, notwithstanding it is a single color as long as it is limited to a specific purpose. For instance, the purple color Pantone 2685C of the chocolate bar wrappers for Cadbury is registered successfully in the UK. It was provided that floodgates will not be opened for the colors to be registered as trademarks per se by accepting non-traditional trademarks as the criteria of distinctiveness are still required to be satisfied. Also, the 3M Corporation has successfully registered the single color yellow as a non-traditional trademark for pots enols. When it comes to the shape of the products, they will be recognized as a trademark if the product has a distinctive shape, as argued in Coca-Cola Company and AG Bar & Co. In Australia, it is seen that the company of Coca-Cola is granted the shape trademark on the unique bottles of Coca-Cola. The case of SmithKline and French Laboratories Limited and Sterling Withdrawal Group Limited was referred to where the 3D shape is registrable as it falls under the categories of mark in Section 3 of TMA 1976. A well-known example of the registration of a 3D trademark is the triangular shape of the Toblerone chocolate bar in the UK. The condition for a successful non-traditional trademark of the shape of the goods to be registered is to have a unique and recognizable shape or packaging. A Malaysian case concerning the trademarks is Yong Tan Hin BS Hong Kong Trading Company and Arnold and Wilton International Limited, where the High Court held that a 3D trademark may be registered, provided that the applicant is a bona fide owner of the mark is distinctive, and the TMA does not prohibit the registration of the mark. One of the examples of the trademarks that have been registered in Malaysia recently is the 3D tiger head of the Maybank Berhad, which is for banking purposes and was registered in 2019. To further illustrate, there has been a registered non-traditional trademark of Lego bricks for 10 years in Malaysia. With non-traditional trademarks, the traders are capable of promoting their goods and services in a way that can satisfy the preferences of the consumers and hence, the demands of the market are met. Through this, the reputation of the brand can be improved, and potentially a symbol of trust between the customers and the traders is established constantly, while capturing the loyalty of the customers. Not only the profit earned by the traders with the registered trademarks will be maximized, but also the mutual benefit between the consumers and the companies is ensured throughout the time. Therefore, it can be clearly seen that when there is a greater clarity in the registration of non-traditional trademarks, this can result in an accurate description of them, enabling the consumers to identify their desired products and services easily. Moving on to the next point, the significance of non-traditional trademark is that the rights of the registered proprietor are protected and they are capable of enforcing their exclusive rights. Section 39, Subsection 1 of TMA 2019 has provided that the registered proprietor of the trademarks will then have 10 years of exclusive rights, which can be renewed for an additional 10 years. Despite there being no requirement in TMA 2019 saying that the owners must register their trademarks, it is highly encouraged for them to do so to ensure that exclusive rights provided in the TMA 2019 are protected against anyone who uses their trademarks. The registration can serve as a legal evidence to claim the ownership of the trademarks. It is because the competitors are prevented from copying the features of the product, such as the shape, packaging, and others, which might confuse the consumers. With registration, the registered proprietor will be granted the exclusive rights to utilize or give authorization to others to use his or her registered trademark. This can prevent the reputation of the goods and services of the companies from being tarnished due to the misappropriation of these marks intended by the competitors by creating similar or identical products and services. The remedies that are available to the registered provider are also provided in TMA 2019 against anyone who infringes his or her right. For example, injunctions, damages, account of profits, as well as additional damages are the remedies provided in Section 56, Subsection 3, Paragraph A to Paragraph D of the TMA 2019. Furthermore, in line with Section 99, Subsection 1 of the TMA 2019, criminal action can also be taken by the trademark owner if his or her registered trademark is counterfeited, as either fine or imprisonment or both will be imposed on the infringer. In contrast, if a trademark is not registered by its owner, only the passing of action could be taken by the owner instead of an action under the trademark infringement, when either a similar or identical mark is used by the others. As a point of illustration, it is seen in Recchi and Klauman and Borden that the elements of goodwill and misrepresentation are required to be satisfied for passing of action to be established. Nonetheless, the possibility of succeeding in proving the elements of passing off action is lower than that in the infringement case because it highly depends on the unregistered owner's capacity to satisfy the requirements. A case in point is Skywards Holding Syndrome Berhard and Ors and Skyward Development Syndrome Berhard and Arnold, where the respondents failed to show that there was a misrepresentation as there was no deception or confusion caused as a result of using the infringing name, and hence the action of passing off could not be established. Despite this, it is arguable that the non-traditional trademark may be difficult to register as a substantive test is applied. From 2022 to 2023, it can be seen from the statistic that there is a sharp 80% decrease in the number of successful registration of the trademarks. In line with Section 3, Subsection 1 of the TML 2019, the requirement of the traditional test where the sign must be capable of a graphical representation might not be easily satisfied, although it is not impossible. For instance, for SAN to be registered as a trademark requires a subjective interpretation of the olfactory sensory system to the scent of a particular item. Besides, it should be clarified that disclosing the chemical constituents is insufficient to make it a trademark, as they are not associated with the scent. To illustrate, it can be seen in the case of Sidman and Doge's patent and Markenum, that the court held that the odor could vary continually, hence it would not be accurate with the disclosure of the chemical components, and the written descriptions depends on the subjective interpretation. Hence, they are all considered insufficient for scent to be of graphical representation. Scent can be influenced by the circumstances around it, such as the temperature, wind, as well as humidity. Since scent is added mainly to make products such as detergents, shampoo, and others more fragrant, it is less likely that the product will be chosen by the consumers based on its sources. The scent should make the consumers feel unique, that it can be linked to the particular product for it to be a recognized trademark. It is clearly shown that the requirements are very strict, particularly for the perceptible signs that are non-visual, such as scent and sound. Therefore, the traditional text provides uncertainty as to whether the sign can be of graphical representation, as there is no specific requirement for the sign to be recognized as a trademark, notwithstanding it is accepted by Malaysian law that sign as a non-traditional trademark may be registered. Nonetheless, Malaysia seems to take the same position as the UK, where it is more significant for the mark to be represented in a precise and clear manner about the claim it seeks instead of being a graphical representation. In pursuant to Article 3 of the European Commission Implementing Regulation 2018, it is stated that the trademark can be represented in any suitable format, utilizing the accessible technology provided that it can be reproduced on the registrar in a clear, precise, self-contained, easily accessible, intelligent, durable, and objective manner to ensure that the public, as well as the competitors, are clear in the subject matter of the protection granted to its proprietor. In order to not undermine the basis of non-traditional trademarks to be recognized as registrable trademarks, it would be simpler if this position is followed by Malaysia, so that non-visually perceptible signs be registered as trademarks. In accordance with the TRIPS agreement, it is also provided that elements such as graphical representation, tangible and physically detectable, are not the must requirements to be fulfilled for it to be a trademark. Nonetheless, if following the UK position, constructing standards might exist when there is no uniform standard of requirements, which will result in a loss of the level of playing field being provided to compare the non-traditional trademarks, or determining whether the exclusive rights should be granted to the owner. Besides, the same strict requirements apply to sound signs. For instance, in Shield Mark BV and Keys, where the segment tax was applied, the court was of the view that it is inadequate for the sound mark to be registered as a trademark with the written record along with onomatopoeia and a series of musical notes. Consequently, the strict requirement that the sign must be graphically represented is subjected to harsh criticism because it will raise the difficulty in registering some trademarks. It is because the signs will usually be represented in the form of written description or scientific illustration indirectly. Therefore, without a translation or interpretation by the professionals, the sound and the smell marks would not be represented graphically directly, notwithstanding the condition is satisfied. Another criterion that is required for the sign to be registered as a non-traditional trademark under Section 3, Subsection 1 of the TMA 2019 is distinctiveness. It is noteworthy that a shape will be rejected as being a trademark if the form is a necessary shape from a technical standpoint or if it is a natural consequence of the goods themselves. An example is that the application for a 3D cheese in the shape of a flower was rejected by the court in Bongren's trademark application due to a lack of distinctiveness. In this case, the court was of the opinion that this is to maintain the freedom of the competitors to use similar products, which ensures the public interest. It is a concern by the Court of Justice of the European Union that accepting a single color to be a trademark will result in the monopoly by the dealer in Liberty Group, PV, and Benelux Remington. Therefore, it is arguable that it is the correct approach for the Court of Justice of the European Union to scrutinize the trader's request for the monopoly more carefully before approving the registration to strike a balance between the protection of non-traditional trademarks and the monopoly over a particular product. Additionally, it is arguable that the recognition of non-traditional trademarks will negatively impact the long term. To illustrate, with the protection of non-traditional trademarks, it is impliedly shown that the companies are encouraged to use standardized features to manufacture particular goods. In such a situation, the creativity to invent and the innovation to improve a product will be hindered because the companies will only focus on the endless profit earned due to the overprotection of non-traditional trademarks if they can be renewed unlimitedly. Ultimately, the designs will gradually become outdated, which would result in a reduced investment in the quality of the products. If the non-traditional trademarks are protected, this may lead to the monopoly of the market by owners because their competitors are not allowed to access similar features for their products and services. The traders might repeat using the features without them noticing as they want to secure the particular trademarks. In conclusion, it is undeniable that the introduction and application of the TMA 2019 has better protected the rights of the registered proprietors by playing a significant role in protecting the non-traditional trademarks, which is to widen the scope of sign as demonstrated in Section 2 of the Act. The amendments implemented in the TMA 2019 have brought the trademark law in Malaysia a step closer to the international schemes. Despite this, it is arguable that these amendments are only theoretical rather than practical due to the strict requirements to be fulfilled to be the trademark which results in lower rates of successful registration of non-traditional trademarks as compared to traditional trademarks. If the difficulty in registration of non-traditional trademarks can be overcome, they can act as a beneficial tool for the companies to be differentiated from their competitors. Despite the difficulties mentioned above, it is clearly shown that such concerns are outweighed by the necessity of protecting these non-traditional trademarks due to the economic interest, encouragement for new types of marks, and the need to expand the purview of trademarks. The reform that can be made is that uniform guidelines should be provided by the World Intellectual Property Organization, WIPO, regarding the criteria of the graphical representation for non-traditional trademarks to ensure a better protection. That's all for my discussion. Thank you for listening.